Welcome to Making the Case. I'm Yodit Tewolde. Questions and requests from the defense continue to slow the pace of jury selection in the murder trial of Gregory McMichael, Titus McMichael, and William Bryan. Before we get into the seventh day of voir dire, let's check in with BNC's Dre Clark, who's in the tight-knit town of Brunswick, Georgia, where many are anxious for this trial to move on to its next phase.
The lawn behind me is where community members come every day to show their support for Ahmaud Arbery's family and to also talk to each other. Today, they invited us into their circle to listen and to learn about the kind of pain this community is dealing with. Georgia, a Bible Belt state. Almost everything here begins with a prayer. Outside the Glenn County Courthouse, a diverse circle of community members, black and white, young and old, men and women, praying for unity, healing, and justice.
It's a lot of people hurt over this him.
Ahmaud Arbery's death at the hands of three white men has caused immense pain here.
3 times in the chest with a 12 gauge shotgun, and every time them bullets went in them, they spread it. Man, come on. That's what's killing my family. Justice for Ahmaud.
Justice for Ahmaud.
Justice for Ahmaud is the rallying cry. Annie Polite, a black woman, is 87 years old. Her back is slightly bent, but she holds her head high. She's seen enough hate in her lifetime. She wants healing.
We just love everybody and want everybody to know that the battle is all of ours.
Glenn County is 70% white, 30% black.
I'm the only white person here right now, and I feel like there should be more of us, like we should be rallying around this community.
Arbery's death has provoked dialogue and understanding.
It's starting to bring people together. It's starting to open people's eyes. Sadly, that Ahmaud's life had to be sacrificed in order for change to happen.
It's very important for us to come together so that we all could live, peacefully.
The healing has already started.
We just need to keep that momentum going after the trial.
No revenge, no retaliation. Justice for Ahmaud is what they want on the black side of town and the white side. His loss could help this town achieve something that it desperately needs: racial harmony.
I don't want to never see this happen no more. Thank y'all.
In recent days, we've noticed more white men and women joining the circle here outside the courthouse. In fact, one white lady said today she's been wanting to come here since jury selection started, and today she finally got the courage to do so, and she was welcomed with open arms. In Brunswick, Georgia, I'm Dre Clark for Making the Case.
We know at least 36 prospective jurors have advanced on to the pool of 64, the number the court needs to reach before the attorneys and the judge begin a new line of questioning to whittle that number down to the 12 jurors and 4 alternates needed to empanel a jury. Joining me from Atlanta tonight is defense attorney Page Pate, a senior trial attorney at Pate, Johnson and Church. Also in Atlanta is former prosecutor Titus Nichols, who's now a senior attorney at the Atlanta Personal Injury Law Group. All right, guys, great seeing you tonight. Let's just dive right in. Within a few minutes of the judge calling court to order today in the 7th day of jury selection, one of the defense attorneys made an effort to preserve the record for possible appeal. Jason Sheffield, the attorney for Titus McMichael, said, quote, "How do we ensure that we say and understand from the court gets placed into the record so that if we lose this case, we can appeal, or we can argue on appeal that either we were not ineffective or where we might share the opinion on appeal that the court failed to exercise discretion." The judge responded in part by saying, quote, "I indicated yesterday that I'm not going to engage in the back and forth. I understand that there are pressures on counsel and I respect that, but I'm not going to engage." Pate, the words, or Page, I'm sorry, the words, "if we lose This early in the trial could be concerning for the three defendants, but it's never too early to preserve the record for appeal, especially if the defense believes there are deficiencies and errors made by the court that they may need to, raise on appeal. So yes, in order to do that, the defense will have to get the judge's rulings as to specific issues on record to raise later if necessary, but the judge won't give a dissertation-like ruling that the defense seems to want because the pool of prospective jurors are present. So who's right here?
Yodit, I think it's getting a little hot in there. They've obviously been going at this for some time now. We're now in the second week of jury selection. I know all of these lawyers. I've been in front of this judge before, and I think the defense lawyers are sensing or having some frustration because as they're questioning these potential jurors, they want to get into information that the judge would like to stop them from getting into, but they're doing it anyway. And the judge is trying to move them on or defer them to some other issue, but without making a specific ruling. So I think we're seeing some of the frustration that the lawyers are feeling because they're not really sure what they can ask and what they can't ask. And honestly, so far, they don't like the answers. And I think that's causing them to be quite frustrated, and they're already thinking about an appeal.
Titus, your thoughts?
I agree with them. Essentially, from a defense perspective, you always want to look towards the future on appeal, particularly whether it's going to be ineffective assistance or if you're going to argue there was a deficiency in the judge's rulings. With the judge not giving a long dissertation ruling, it limits the defense as to what they can argue on appeal. What they want is for the judge to explain the judge's rationale in detail so that if they do lose on appeal, they have more to pick apart. They can say, well, the judge based the ruling on this fact and this fact. That was erroneous because of X, Y, and Z. However, if the judge is keeping the rulings very short and succinct, that makes it much more difficult. I remember when I was a law clerk, my judge used to have a saying that I might not always be right, but I'm never in doubt. And so essentially from the judge's perspective, the judge is giving a definitive ruling without, like the judge said, not engaging in the back and forth, because that tends to undermine the finality of the judge's ruling.
All right, let's talk about another request the defense made. They asked a judge to expedite the removal of jurors for cause for the jurors that were already deemed improbable due to exemptions. William Bryan's attorney, Kevin Gow, said, quote, "Jurors have no TV and nothing to do for 12 hours. We are going to have a revolt by the jury pool." The judge responded by saying, quote, "We are not going to hasten these proceedings." He went on to say, "I apologize for folks who believe that we are taking up too much of their time, but I hope folks can see the bigger picture here." Okay, so Paige, most of these prospective jurors have made it pretty clear that they don't want to make it onto this jury. But on top of all the other reasons why people generally try to get out of jury duty, they now have to waste away sitting in a room for hours on end, waiting for their number to get called for a process they may not even see through to the end. Listen, I've never been summoned for jury duty and have always wanted to go through the process, but I'm a trial nerd, so I'm in that 1%. Should courts find ways to make jury duty less painful?
I think so, and I think some courts do. I was summoned for jury duty. It's been a couple of years now in DeKalb County. We did have a TV, although it just kept showing the same thing over and over again about how to be a juror. So I don't know how entertaining it was, but at least it was something to watch. The situation, if you're statutorily able to step aside and be excused because of your age or disability, you can make that known before you have to come down to the courthouse. So I think the judge expressed some frustration about that, said, look, if people don't want to show up and they're not going to serve, they can let us know. They can tell the clerk's office before they have to submit to the questions. But he also said, and I think this is absolutely true, there are probably some people who would otherwise not have to serve who want to be there, who want to go through the process, who want to do their civic duty. So give them that opportunity. It's going to be a long day, but clearly if you're picked for this jury, it's going to be a long month. So let's get through the process.
Your final thoughts, Titus, before we go to break.
I've actually been summoned for jury duty, and it was when I was still a prosecutor. And so I know exactly how they feel. You have to sit in a room, then you get moved to another room, then you get moved to the courtroom. And I knew I wasn't going to get picked, but I still had to sit through the entire process. It's unfortunate, but when dealing with the government really does not have an efficient way of doing this outside of how we're doing it now, because they want to make sure that each juror is being screened properly and fairly. And if they take into consideration whether a juror is bored or whether they want to leave, then it's going to open the door to potential problems. So as painful and as unfortunate as it is, the jurors are just going to have to bring a book with them. That's why I always tell people, bring a book with you because it's going to be a long day.
All right, Paige, Titus, stay with me. We've got more to discuss on day 7 of jury selection, including whether or not this jury will be sequestered.